Welcome back to Ring of Fire. I'm Mike Papantonio. The U.S. Supreme Court recently heard arguments on a case that could greatly reduce the already weakened power of the American Labor Union and, in fact, decimate the middle class in the process. I have attorney Howard Nations with me now to tell you what's happening and what's likely to happen as far as result from the Supreme Court. Howard, Scalia, Roberts, Thomas, all the usual suspects, Alito, they all have their chance again to do more harm to America's middle class and working poor. What's before them right now that probably is going to go south for that group of people?
Well, last week, United Here versus Mulhall, the Mulhall case, was argued before the court, and it's been described by the pundits as the most significant labor decision in the last generation. The issue they're facing is an extremely important one. The issue is the constitutionality of these card check neutrality agreements. These are agreements that have voluntary terms between the employer and the union. Under those terms, the employer restricts their union busting activities, and they commit to recognize the union and negotiate if the majority of the employees sign union cards. Then the employer prefers the government supervised elections, but the unions agree, no public shaming, they call off all public pressure. So this is a totally voluntary situation between the employer and the unions.
Howard, it seems the important thing is to me, over the years since the New Deal's National Labor Relations Act came into place, unions figured out and employees figured out that it really didn't work that well. Right. There wasn't really enough that was put down in paper to give them a lot of guidelines. So they started working between themselves. They said, look, let us do our own negotiating with the employer. Let us try to go out and accomplish something by fashioning something that the employer wants and that the worker wants. Give us some examples of that. I think of the issue with the casino case down in South Florida.
Yeah, under the new norm, when they figured out that the NLRB implementation of the National Labor Relations Act simply was not working, it wasn't working, it was very anti-union, they created a new norm. And under that new norm, the unions adopted comprehensive campaigns. They included not only their strikes, but community pressure, consumer pressure. They used every legal, media, and political aspect they could come up with. And then they made these side offers. They offered employers enticements. They would give them lobbying assistance. They would agree to cap contract costs. They would exclude other groups. And the results of the new tactics were that the unions get recognition, they get a contract, they get no retaliation. Now, the case you're talking about, Mulhall, is a perfect example of this. Unite Here Union and Mardi Gras Gaming reached an agreement to use the card check system. The union agreed no strikes and pickets, and then they made a side deal that the union would assist the company in a Florida gambling ballot initiative. All the parties were happy. Everybody's happy. And that things are working as they should. And then enters a third party, which is the Republican anti-union right-wing foundation, who finds an employee to challenge it and call it illegal. And what they're saying is that when an employer signs the card check deal, that they're giving a thing of value to the union officials, which is prevented by federal law.
In other words, here you had the labor unions happy, the employers happy, both of them get something out of it, life goes on, but some third party comes in simply, and I got to tell you something, there's no question that this was done to get this case before the United States Supreme Court.
No doubt.
When you really they wanted to get in front of these right-wing trolls that have been placed on the court, these politicians that wear black robes, Alito, Scalia, Roberts, Thomas, these characters that they know they can count on every time, including Kennedy most of the time. So they wanted to get this issue put in front of the Supreme Court because they knew this was their chance to finally kill unions in America. Isn't that kind of how this developed?
Well, it absolutely is, because Professor Sachs, the labor professor at Harvard, said that all such organizing, all successful organizing that goes on these days uses these alternative ground rules. And if you declare those illegal, Mulhall could effectively outlaw union organizing or outlaw effective union organizing. I mean, yes,
And so-
this could stop the whole thing.
Now you have the Supreme Court. The next thing they're taking a look at is even alternative labor groups that aren't even unionized.
Right.
People like the Walmart group that goes out on a Black Friday strike. They even want to restrict what these people can do to say, damn it, we got to make a minimum wage. We have to be paid a decent salary and some protection here. Isn't that where this is headed?
It is, and what's happening here, there are two attacks on this by the Republican Party. The congressmen in the Republican congressmen are offering legislation to do exactly the same thing they're trying to do in the Mulhall case. And then, of course, they're hoping that in the judicial wing of the Republican Party, that the Supreme Court will also accomplish this for them. And
I know you've called this before. You're calling that the Scalia is going to do exactly what the really rabid right-wing Republicans want, and that is to bust the unions again. Isn't that your call?
I am, and let me tell you in one sentence how bad it is. Craig Beck, the former NLRB member who is CEO and general counsel of the AFL-CIO, says Mulhall, taken to its logical conclusion, would criminalize, listen to that, would criminalize a large swath of ordinary voluntary labor management relations. The implications are really sweeping.
Howard, thanks for joining me. Another story that just makes your gag reflex almost respond. Thanks for being here.
Sure, Mike.